All right, good morning to all. Smaller crowd today as expected, but smaller does not mean anything other than more intimate, and we can kind of delve into those details. So let's take a small crowd approach to this particular session, and I would encourage you guys to interject while I'm speaking with questions. Simply put your hand up through Zoom, and I'll call on you even while we're in the middle of things. So you don't need to wait. Let's just make this a more interactive session and we can go from there. So a couple of normal caveats. We begin at 10:05 promptly, and then we'll go till about 10:50-ish or so, have 10 minutes for questions. Remember, although our video channel, although our Facebook channel is private, our videos are public. And as a result, anything that is said on these channels will be seen on any number of forums. I can tell you that my last time that I did a Form 101 video, we actually had a lot of interest retrospectively. By a lot, I mean, we're close to, I think, 8,000 views presently on the Form 100 or 101. I mean, this was done a couple of years ago. But I'm pointing it out to you because even though it's a smaller group of 10 or 12 or whatever it is, there's going to probably be quite a few people who have an interest in this as people start their careers. So do keep that in mind as you ask your questions. We have an exciting roster of discussions that are going to take place. We're going to be concentrating on people who are newer to the profession for the summer, and we'll be getting back into the heat of things come September for the more seasoned practitioners. Upcoming is going to be a talk on getting started in your careers, both for lawyers and realtors. And we're going to have some people who have just kind of been through that experience come and present. So we're going to have some younger presenters, which I'm excited about, and we'll talk about that on the forum shortly. Regardless, as it's now 10:04 and quickly going to be 10:05, I am going to begin the fun. So for the purposes of today, I am going to be referring to the Form 100, and many of you may have seen this particular form banting about. The OREA Form 100, this is a form designed by the OREA for educational use. We are not commercial use. We do not get paid for these videos. We use Form 100, Form 101 for the purposes that they're intended, that is to say education of professionals in this area, and I will be using those forms today. And you can tell that these are the educational forms because, of course, they have the red highlighted stuff all over them. The normal forms, of course, do not have the red. That is purely explanatory. So with your permission, my goal today is to go over the Form 100 and the Form 101 and really sort of delve into what is said in the standard form. So many people who do out these agreements do them, turn immediately to Schedule A, and then say, all right, everything here is standard, don't worry about it. And to some degree, they're correct. The reason for standard form is you don't need to agree with it. It is largely uncontroversial and helps you through the process. But it doesn't mean that as a professional whose primary duty is that of competence, that you do not need to understand the details. And so with your permission, I'm going to go into that now. Let's start with the beginning. And the beginning has Form 100. Form 100 is for freehold land. Form 101 is for condos. And while you may know that, I will point out that there is also particularly for newer agents, there is something called a pottle, a piece of tied land. There are any number of projects that exist in the city or in the GTA, where municipalities simply don't want to absorb the cost of new roadways. So if you think about it, when you build a roadway and give it over to the city has to collect garbage, it has to light it up, it has to be responsible for sewage repair and for the road repair. And the cities have found a really easy way of actually solving for that cost by taking people who are building subdivisions and saying, hey, you know that road? You are responsible for that road. We are going to condoize effectively that road. So you can have freehold ownership. You're going to have actual ownership of your property, but each person who has ownership of the property, one of the obligations in rem that flow with the land is the obligation to maintain the road. That is what a pottle is. And the pottle uses its own form. It didn't used to have its own form, but the pottle uses Form 111. So be advised that there are effectively three forms. We're only going to be going over the two most common ones, but the 100, the 101, and the 111 constitute the quivers in your bow, constitute the arrows in your quiver when you approach your basic parcels of land for residential property in Ontario. All right, so you start with the date. I don't really need to talk about what a date is. You got that. The buyer and the seller. Let me start with the buyer or the seller. You will often see someone who writes the following: Mark Morris, comma, in trust, or Mark Morris in trust for a corporation to be incorporated. I just want to point out what that is. So there's three different types of buyers. You can put down your name, in which case you're totally on the hook. Great for the buyer. The second thing I want to point out for the buyer is that you can take it in trust. And if you do that, what you're doing is you're basically saying, even though my name is on this title, the beneficial person, the person who is actually responsible, is the trust, is whoever it is that Mark Morris is holding this in trust for. And if it just says in trust, it can very well be for a corporation that has no assets, meaning that if that corporation does not proceed forward with the conclusion of the deal on the day of closing, you can only sue it for its assets. And if it has no assets, you have nothing to go after. And then last, there is corporations. I mean, there's other forms of legal entities, but we're taking our crack at the most common. And corporations, we'll talk about how to sign for a corporation today later on. From the seller line from an agent's perspective often causes confusion. If in fact you have a sale and you are trying to effect the proper seller name, there are several times that people get screwed up. Obviously, you want to have the same names as are recorded on the land registry because they are the official sellers. How do you discover that? You do not discover that through GeoWarehouse. You do not do that through a GeoWarehouse simple property search. And the reason is because of a glitch in GeoWarehouse. If you go to GeoWarehouse and simply type in the address on your GeoWarehouse button, it will simply reflect the name of the last transferor on the property. So let me give you a hypothetical scenario. And as a result, in order to figure out who really owns title, you have to pull the parcel register. You have to pay the $32. There's something called property reports when you pull up on GeoWarehouse, and you have to buy that parcel report. It costs $32 in order to figure out who really owns a property. What am I yammering about? Well, let me give you a scenario. Let's say me and my brother went ahead and purchased a property collectively. And my brother, so I own 50%, my brother owns 50%. And my brother passes away or sells his interest to a friend. The last transfer that will be recorded on GeoWarehouse is the sale from my brother to his friend. But my brother was selling what to his friend? He was selling only 50% of the property, right? Because that's what he owned. Me and my brother owned 50% each. My brother sold 50% to his friend. And on GeoWarehouse, that would only be recorded as being owned by my brother's friend, not the 50% that I own, because the last transfer did not reflect anything to do with me. It was just my brother who sold it. So I'm just pointing out a simple glitch in the GeoWarehouse system. As a seller, it's vitally important that you actually check who has title by paying the $32 on GeoWarehouse and pulling the parcel report. The parcel report for your instance looks, oh, well, I have a background on, looks like this. It says Ontario on the top. I'll try to share it with you later on today. Sellers can also be people who have passed on, people who have died. And if so, the seller can only sell the property if, in fact, they are authorized to do so. So if someone has died, then the seller is the estate of that person, signed by the trustees. So to be clear, you can only transfer a property when you get probate. Probate is the process of the court where the court says, we look at this will, we approve the will is good and valid. But the estate trustees under a will prior to probate being processed can sign an agreement of purchase and sale. And so the name of the seller in that instance is the estate of the deceased, and the signatories to and as such an estate are the estate trustees. So if it's Mark Morris that passed, it's estate of Mark Morris. And let's say that I left my brother Simon as the estate trustee. He would sign the agreement of purchase and sale as Simon Morris, comma, trustee. Of course, he would need a provision in Schedule A to account for the fact that Simon Morris, trustee, cannot transfer the property without the probate being obtained. We've had sessions on this, but the be all and end all is it's vitally important that Schedule A contain an allowance for the court's process, which can take several months to obtain probate, allowing for extensions on that basis accordingly. If this is your first time dealing with such an instance, please consult your lawyer or your broker of record who will give you further information. Let's move on. The real property. So the real property is describing the address of the property. And it contains a couple of critical words, including this, more or less. So the address is the address, fronting on, side of, in the city of. I assume you know how to do all that. Having a frontage of blank by blank, and it has the words more or less. For residential deals, the insane accuracy of to the inch is not what the courts require. In fact, the case law is replete.
You'll pick Benji up.
The case law is replete.
Oh, I guess, how do we pay her? I guess
Sorry.
e-transfer.
Sorry, there we go. I'll just mute you guys. The case law is actually replete with instances of people who have gone ahead and realized only after they had a firm agreement of purchase and sale that the property that they thought was 2,800 square feet was 2,500 square feet, or that the property that they thought was 60 feet across was 55 feet across. And in every instance where it is a residential deal, the courts have said WYSIWYG, which for those of you who are young, you have no idea what I mean. But for those of you who grew up in the 90s and 2000s and are familiar with computer terms from flywheel of dot matrix printers, it means what you see is what you get. You knew what you were getting. You paid for what you're getting. Thank you very much. That discrepancy did not matter to your purchase, and we're not going to hold it as important now. This is vastly different than commercial deals where you're purchasing, say, acreages of land, and every single acre permits for additional homes, which of course affects the substantive value of the site. So really it's dependent, but we're talking here about basic residential deals, and the more or less client line here really does cover your rear such that you have to be accurate. There has to be no negligence on your part, but if there's an inaccuracy in the description, you're largely good. And then it has this word legally described as, where you immediately take the description of the property from Geo Warehouse. It's really quite critical as new agents that you do not just copy and paste from Geo Warehouse what is contained there, because contained in the description are often a variety of things which are important, such as S/T, which means subject to. And S/T may mean subject to an easement. Well, if that's the case, you may want to pull the easement and discover what it is you're putting in. Because if you put S-2 easement, whatever it is, then that is what someone is acquiring. They're acquiring this property subject to an easement. You can't object to the easement if it's subject to and you're describing it and that's what is being purchased in the first place. So you really want to make sure that there's no subject tos or executions. Executions are sometimes, you sometimes see subject to an execution, and an execution cannot be included in the property description. It should be, or if it is, you have to put in Schedule A that all executions are to be cleared. And we could talk about that in some more detail if you like, or if anyone has any questions about it, I can pause and ask if anyone has any questions. We have about 25 people here, so it's manageable. Does anybody have any questions so far as to anything I've said, or can I keep moving forward? You can just unmute yourself and speak if you like.
Hey, Mark.
Hey. Hi,
If there's an ST in Geo Warehouse, so what would you do with it? And what would you do with the description on the APS in the end?
So you would include subject to the easement, but what I'm getting at is that, because that's part of its description, what I'm getting at is you can't just copy and paste. You have to investigate what that easement is. And
Okay.
Geo Warehouse, by the way, provides you with that ability. You know how it says subject to, and then it says AS7435, and you're just like, what is that? Well, if you go to your Geo Warehouse bar and literally type AS7235, whatever the instrument number is, into the Geo Warehouse bar, the very place that you put the address, it will then pull up that instrument. It's like you double click on that instrument with the land registry, and for $3, it will show you what that easement pertains to. That's what lawyers do. It's not magic. And you have the ability to do that as agents. So if you're a buyer or a seller, looking at the property description is actually part of your job. You may not understand it all, but you have the ability to pull it up through your Geo Warehouse system and investigate what the devil it is it's trying to tell you, even though it's using these things like subject to and executions and everything else. Does that make sense, Ivar?
Yeah, thank you.
Okay. Everyone understand how to pull up an instrument? I know most people don't realize they can do that, but you literally, the Geo Warehouse search bar is very powerful. It's not just for addresses and names, also for instruments. Sorry, we have office dogs. It's also for instruments. So you can just put the underlying instrument in, pay $3, that's all it costs, and it will literally pull up the 5 or 6 page document showing you what the easement is. Oftentimes, particularly with new builds, you'll see easements that give a builder, as an example, a right of entry into the property for the next 4 years to finish off the asphalting and the backyard landscaping and everything else. Do pay attention to it. Okay, purchase price. Well, if you don't understand purchase price, then perhaps we should have an entirely different discussion, but I'm going to skip that. I'm assuming you do. The deposit. The deposit needs to be paid. First of all, the deposit is not a requirement of this agreement of purchase and sale. Excuse me, I know that this is going public, but I'm going to use some Yiddish here. God damn it, the deposit is not a requirement of the agreement of purchase and sale. The deposit can be zero. What is the consideration of the deal? Someone, hands up, unmute yourself. Tell me what the consideration of this deal is.
Seal, 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 seal.
Okay, that's one. Seal, it's been signed under seal, absolutely. Let's say you have an agreement that wasn't signed under seal. What is the consideration of this deal?
Ooh.
Deposit, I guess.
I'm going to tell you. A consideration is a present or future event for value. So what is the nature of what's being contracted here? The nature of what's being contracted is I'm promising to give you title, and you're promising to give me money on the closing day. If I have a $0 deposit and no seal, is there still a valid contract? Is there consideration? Yes.
Yes, the promise.
It has nothing to do with the seal. The reason the seal is there, by the way, is for the purposes of the irrevocable, which we'll talk about, because when the at the time when the buyer extends an offer to the seller, that's usually the way it goes. The seller has not yet agreed. There's been no agreement. And thus, what keeps it irrevocable? The seal. That's the reason for the seal there. But in the event that there was no seal on an agreement of purchase and sale and there was no deposit, is it a valid contract if fully signed? Hell's yes. That was my second Yiddish. I only get 3 Yiddish per session. Now, the deposit. It must be paid within 24 hours of acceptance of this agreement. See that? If the deposit is not paid within 24 hours of acceptance, I'm not going to go into this in great detail. Just trust me on this, new agents. If your deposit is not paid within 24 hours, the seller at its option is allowed to terminate the deal and resell. Just FYI, that's how important it is to get the deposit there. The buyer is not allowed to walk away if they don't give the deposit. That's not an option. The deposit is not the consideration of this deal. The deal is already in place. You don't pay your deposit, that's just a breach. It's not a termination. Many people try to get away with not paying. They have buyer's regret the night after. This is not BC where there's a 3-day cooling off period. You are screwed if you have consummated the deal, signed it without conditions, not bringing in the deposit, maybe a technical obstacle. It is not a legal obstacle. You will be sued. Makes sense. Anybody have, I'm going to pause. Does anyone have any questions so far? We're only on page 1.
Please remind them that this includes weekends.
And it includes weekends. I don't need to remind them if you just did, Sandy, but there you go.
Hey, Mark, can I make a comment?
Yes, of course.
Just so people don't get the wrong impression, I think when we're talking about, when you were talking about the square footage and courts addressing square footage, that's between the buyer and the seller. Realtors are also under TREB rules. So keep that in mind. Doesn't mean you can just completely screw up the square footage and it won't matter. You're still under the TREB rules that you can't misrepresent.
Totally. And you'll note that when I was talking about it, I specifically said you have to be competent in what you do. I said, but if the end result has released an error, I actually said that specifically because I knew who I was speaking to. But if the end result has resulted in a small error, then that is where the coverage comes in. But absolute competence is a requirement of all agents at all times. And by the way, for the new agents, I'm going to tell you a bit of a story. When I was a young lawyer, I went to court for the very first time. This is a great story. I haven't told it in a long time. I went to court for the first time, and I'll never forget. I was actually doing a rotation with the Family Responsibility Office, which are a bunch of guys who don't pay child support. In my 3 months there performing before the court, I didn't see a single woman. So I'm going to say guys that don't pay child support. And basically the province of Ontario throws them in jail if they don't pay child support. And I was the person who was assisting my principal at the time with throwing these people in jail. Anyways, so I was there for the first day to watch a proceeding. And it was provincial court, which meant that articling students were allowed to go before the court. And it was provincial court. And I'll never forget, we got into court that day, into the anteroom, and we looked at the TV, and it turned out that 2 planes had crashed into buildings that very day. It was September 11, 2001. And my articling principal, her husband was in New York downtown at the time. And she looked at it and she said, "Oh my God, take these files, I gotta go." And she ran out of the building. And so I hadn't prepped. I didn't know what my job was. I had 12 people who were going to go to jail that night, and I had 12 files in front of me, and I really didn't know what the essence of my job was. It was crazy. And there I was in court before Justice Nordheimer. I'll never forget him. And Justice Nordheimer sat high on a bench, and he looked down, and he had these small little rimmed spectacles, and he was an old man, and he looked down. There's a new Nordheimer on the bench, not a different one. And he looked down at me with his spectacles. And I remember saying something just so embarrassing. I remember saying something like, Your Honor, I throw myself at the mercy of the court here. I don't know what to do, yada, yada, yada. And I'll never forget, Justice Nordheimer turned to me and he said, "Mr." And he looked, I remember he paused for effect and looked at this thing and said, "Mr. Morris," he said, "you are here before me in court." He said, "and every person here has the potential of going to jail." He's like, "I do not care that it is your first day. I do not care that there are towers that are knocked down in New York. You are before me. You will take 5 minutes. You will compose yourself in that room, and you will become competent at what you do, because that is the expectation." And it was totally unfair. And by the way, the FRO had to adjourn like 12 files like for 6 months. And I just caused massive backlogs in the system. It was terrible. And no one was impressed. But the principle is the truth. And it's true for agents and it's true for lawyers. If you take on a task, if you are listing a property, if you're buying a property, to David's point, competence is the standard of competence expected of an agent, not a new agent, not a first day agent. You are before Justice Nordheimer, you shall act accordingly. And the way you are competent, if you don't know what you're doing, is by bringing in help and saying, the words "I don't know." It doesn't make you look good, but it's accurate. Sometimes people respect it too. So to be clear, I am not suggesting you make errors. I'm suggesting you hold yourself out to the very same standard that seasoned agents hold themselves out to. I'm suggesting, however, David, that sometimes even with those seasoned standards, errors are made, and that's how the court deals with those types of errors, separate and apart from professional obligations. Does that make sense?
Thank you.
All right, next, let's keep moving on. So the irrevocability. So the irrevocability is, of course, the period by which the buyer usually has an offer extended to the seller. Now, until the seller signs back and accepts an offer, the seller can accept as many offers as they want. And the buyer can do nothing. The buyer cannot withdraw the offer. Why? Because it's signed under seal. We've already addressed it. Otherwise, I would have gone into a big thing about seals at this point, but we've already talked about seal. And then we have this thing called the completion date. And the completion date is to take place at 6 p.m. on the day of close. Now, practically, almost all of these things close by 5 p.m. on the day of close because the land registry closes down at 5 p.m. But remember, and most people don't know this, and perhaps this is a bit advanced for a Form 101 100 session. The land registration, the registration of your ownership is not a necessary component of closing. In fact, in the entire Form 100, there's nothing that calls for the registration of your ownership ever. It's not a requirement. Yes, it's what you want to do once you own a property. Clearly, you want to own the property in the land registry. You want to register it. But as between the buyer and the seller, registration is not a necessary component of closing. All that's necessary for the day of closing is that money transferred to the other side and the other side release the requisite deliveries, the key, and the ownership of the house. That's all that's required. And as a result, the 6 p.m. deadline is very helpful to have because it means that even if the land registry has shut down, the deal can still conclude until 6, meaning the money can still get over there and they can still release the keys, even though registration hasn't occurred. And that's an escrow closing. That happens all the time. So many of you may have heard and not understand, if the land registry shuts down, why is there till 6 o'clock in the agreement? Well, there's still 6 o'clock because it often can take until that time to get the money over, last minute hitches and everything else. And in the event that the land registry is shut down, okay, you register the next day, not a big deal, not a necessary component of closing. By the way, as an aside, if all, and this is just for the lawyers on this channel, if all requisite deliveries have been transferred on the day of close, that is to say, you've made all payments and transferred all docs, and they've transferred keys and all docs, there is no closing in escrow at that point. The seller's lawyer is not able to say, we are permitting or denying a closing because of lack of registration. Every lawyer tries, because most lawyers don't know the law in this area. And at that point, you turn to them and say, registration is not a necessary component of closing. We are the owner bona fide of this property. We have delivered all deliverables. You have delivered all deliverables. That we haven't registered is totally irrelevant. You give me that key and give me access, or else I'm breaking down the door, which is my right, and billing you. Okay, for lawyers, I'm going to just don't worry about this agents. Don't worry about, if you're an agent, don't worry about it. But for lawyers, any lawyer have a question on that point. It's very important because lawyers don't have that knowledge. It's very annoying. Okay, cool.
Yes, please. As a lawyer, is there case law or something we can tell the other lawyer when they refuse to release the keys or say, no, your clients cannot move in when everything has been exchanged?
No, there's no case law on it. It's just the law. Like I have done this many times with lawyers. I've called up the lawyer and I've basically said, please pull your head from your ass and understand the law. There is no registration is not a necessary component of closing. All requisite deliveries have been sent pursuant to the DRA. Access is mandatory. Screw off. And if you don't give me access, I'm complaining to the LSO because you do not understand your job. Believe me, when you threaten the LSO, they will back down.
Okay, thank you.
No problem. Okay, that's more for the lawyers. Let's keep going. Notices. Notices are critical, both for lawyers and realtors. Please do not ignore this. Please put in some form of getting in touch with people. Now, don't get me wrong. If you don't put in anything, it's fine because it's still saying that the brokerages are being appointed and the brokerages fundamentally have their own faxes and emails, but it's always better to have the agent's email address here and here, because it is a basic tenet of offer and acceptance that offer and acceptance must be made in the manner prescribed by the agreement. So not only do you have to have a meeting of the minds and consideration and everything else, but communication must be timely. Meaning that if you give someone until 6 p.m. in order to, let's say you have an irrevocable until 6 p.m. on today's date. If you sign this agreement back, but do not communicate it, it does not matter. The fact that there's signatures, even DocuSign signatures attesting to dates, does not matter because it wasn't communicated back in the manner prescribed. And what's the manner prescribed? Well, the manner prescribed is Section 3. And it says that all communication is to be delivered to the brokerage for this deal, or at the following faxes and emails. What does this mean? This means that if this here is not filled out, generally, you're still communicating with Gary, the real estate agent. And so you're using GaryShanling@gmail.com to communicate back and forth. And so you're going to give a notice to Gary Shanling. Okay, that's fine, because technically Gary Shanling is, I guess, part of the brokerage. But what you should be doing is you should also be, if there is no Gary Shanling here, sending a fax or an email directly to the brokerage pursuant to the notice provisions, because that's what's called for. From a lawyer's perspective, in the event that a seller or a buyer refuses to ultimately maintain or retain a lawyer, or if you do not know who the lawyer who will be retained is, and you're acting for the buyer, this is the provision that permits requisitions and tender documents to be put on the brokerage and will be enforceable in law. Meaning, if you do not know who the seller's lawyer is, you just treat the brokerage as the seller's lawyer, and they won't have a clue of what's going on. They won't have a clue of why you're sending over requisition letters and tender documents. Who cares? You're not doing it for them. You're doing it to show the court that you have given notice in accordance with this agreement under Section 3. Does that make sense? Going to pause. Everyone gets that? Okay. Chattels and fixtures. All right. To be clear, for those people who are starting out, chattels are things that are not included with the home by right. Fixtures are things that are affixed to the home and are thus included and do not need to be mentioned. The big question, of course, is what is a fixture? What is a chattel? Every time someone asks that, I want to blow my own brains out because there's no definitive answer. Is a 300-pound garden gnome, this is a true case in the small claims court, is a 300-pound garden gnome a fixture or a chattel? Well, you can't move it, and yet at the same time, you can move it. What is it? Well, anything that is in any way desirable for your buyer that they want, just note it as a chattel included every single time, right? Just, even if it's a fixture, even if it's called a light fixture, just include it. Just put it into the chattels. Why? Because then there's no question. Because then it's either a fixture or it's a chattel that is included. And any fixture that your seller wants, make sure you include the fixtures excluded. Now, the rental items. Generally, there are 3 primary rental items. We have a real problem with rental items in Ontario, and specifically NOSI's, Notice of Security Interests. The worst companies in the world, you may think they're Ticketmaster. They aren't, although don't get me wrong, it would be great if we could all attend a Taylor Swift concert. The worst items in the world or worst companies in the world are Reliance and its ilk. And I know I'm speaking badly of someone who just filmed a commercial at my place and paid me money, so I'm already in conflict. But Reliance and others are just absolutely terrible creatures. And what they do is they say, well, you know, these hot water tanks that cost $3,000? Well, people don't really understand financial math, so we can charge them $10,000 and just have it paid out over the course of 15 years. And then we're going to register that interest on title through what's called a notice of security interest, which, by the way, the province has started to crack down on seriously. That's not what this is about. I'm not going to go into it. The be all and end all is this. If you do not write anything in this provision, then there can be no associated rental items and the seller must pay them out. If you do write something in here, then whatever that monthly cost is, whether it's a hot water tank rental, which is the most common, an air conditioner or furnace, or a soft water rental or whatever it may be, has to be absorbed as a monthly cost by the buyer. As a matter of course, hot water tank rentals run between $30 and $50 per month and are not entirely significant, whereas air conditioning and heating units run between $150 and $200 per month and are significant for most people. And as a result, do keep in mind that if someone is saying you're going to take on the furnace or the air conditioning unit, you are taking on significant cost. Make sense? All right, I'm going to pause before I get to HST because undoubtedly people are going to have questions. I see that there is comments. Chanel says Reliance is Snap on the worst. I feel you, Chanel. That's for sure. Okay, I'm going to move on and I'm going to share the screen and we're going to deal with HST here. Okay, HST. So HST is leviable on everything in Canada. I bought my PS5 from a random dude in a parking lot at 1 a.m. in the morning from a Shoppers Drug Mart. That's true. By the way, I also bought my baby monitors that way. I don't know what that says about my shopping habits, but regardless, there it is. And when they did, they said, pay me for the PS5, pay me $400 in cash. I don't remember what it was, $400 in cash. So I brought out $400 in cash and paid him. Technically, I should have paid HST on that. Technically, I should have paid HST on that. Technically, by the way, I should have also asked him if he was a non-resident of Canada for tax purposes and gotten him to sign a Section 116 stat dec. Same is true of your garage sales or anything else. There are a couple of exemptions where HST is not leviable. One such exemption is used residential surplus. Under the Excise Tax Act, it is exempt from HST, used residential surplus. So note those words, used, not new construction. New construction has HST. Residential means anywhere where you normally store underwear. So do you store underwear in your house? You do. Do you store underwear in a duplex? You do. Do you store underwear in a triplex? You do. Do people's use of 100-unit building, you know, one of those big apartment buildings, what's the primary use of that building? Is it to store underwear? It is. No HST. This is different than any commercial property. This is different than most vacant land. This is different than commercial farmland, which all attracts HST. That's the reason for the Form 500, which we're not discussing, but that's commercial, where HST is always included in. But HST, as a matter of course, is not included in places where you store your underwear. And accordingly, for the vast majority of us, whether we choose included in or in addition to, it makes very little difference. But of course, who is the person who can determine whether or not they've used the property for the purposes of storing underwear? Not going to use, but used. It's the seller. And so generally, because you can't tell if the seller took an input tax credit, which is the way of saying, you know, as real estate agents, when you buy gasoline and you pay HST on it, that 13% that you pay to the gas is written off as against your commission HST. And the only HST you remit to the government is after your expenses. Those are called input tax credits. And you don't generally take an input tax credit if it's a residential property, even if it's for lease. Even if it's for lease, you don't take an input tax credit. And as a result, HST is not usually leviable. But there are instances where someone may have chosen to take an input tax credit. Let's say that they were using their house as, I don't know, a massage parlor or an osteopath clinic or whatever it may be, and they've written the whole thing off and they've claimed HST deductions and everything. Okay, in that case, you put included in as a precaution, specifically because in the event that HST is leviable because of the seller's use, it's the seller's problem. You just take it off the purchase price and let them deal with their tax. Does that make sense? I'm going to pause for a minute. Anybody have any questions about HST? I mean, obviously HST is very complicated. And in fact, Matt Wilson did an entire session on our video channels that dealt with farmland, commercial land, and HST implications. I encourage you to watch it if you have further questions. But from a residential perspective, it's pretty simple. You store your underwear there, you never had a business outside of renting your property for residential rent purposes, then it is exempt. Is that clear? Are we good?
Quick question. What about with everybody doing this work from home and a lot of, like, for example, lawyers who shut down their main practice location and doing it through home?
Well, most of those people who did that were smart enough not to claim their home as an office, or if they did, through temporary exemptions, did not use input tax credits for that. Having said that, if you did do that and you're selling your property, then you have to speak to your accountant. There is a good reason why you don't allocate your home's portion that you're using for business as an office. And the reason is because in the event that you do, it's not capital gains exempt when you sell, right? Which is the case for your primary residence. And so most lawyers, upon discovering that, most professionals, upon discovering that, have maintained that this property was not used for a business. But in the event that it was used for a business and input tax credits were claimed, you have to speak to your accountant before selling. And it's for that very reason that the HST is always included in, to make it the seller's issue. Make sense?
Thank you.
Now
Mark,
we get to...
had a question?
Yes, of course, Oliver.
Well, what if somebody buys a principal residence that they're going to live there, but they buy it under their corporation?
So there's ways of getting around that if you're buying it in a corporation. I mean, there's very little reason to do it, but so long as the corporation was holding it in trust for the person, there are ways of actually putting it forward to the CRA that upon sale, it is a residential property, but you really need to discuss that with the accountant. And with your permission, Oliver, I'm happy to discuss that offline. It's just a bit beyond the scope here. Though I do want to acknowledge Oliver as the hero who provided legal review with a television for Realtor Quest recently. Thank you, Oliver. You're welcome to ask any question you want for the next year. That's the payment. All right. So now we get to the heart of the agreement. And the heart of the agreement is found in Section 8 and Section 10. Section 8 says as follows: the buyer shall be allowed until usually 2 weeks before closing to examine title at the buyer's own expense. And I'm just skipping a couple of words here because it doesn't really matter. To satisfy, as long as you put 2 weeks before, it's fine. To satisfy the buyer that there are no outstanding work orders or deficiency notices affecting the property, and that its present use blank may be lawfully continued. All right. Now, the first thing I want to point out is that if you fill nothing in where it says after present use, it's still a valid sentence, right? Let's read it. To satisfy the buyer that there are no outstanding work orders and deficiency notices affecting the property, and that its present use may be lawfully continued. So if you do not know what the present use is of a property, or if you're unclear, leaving that blank is a perfectly acceptable thing to do. You're just saying the present use can be lawfully continued, whatever that is. If you put something in, like zone duplex or whatever it may be, then what the seller is saying is, I'm committing that that it is properly a zone duplex, that there are 2 units. So let's keep on reading. That there's no outstanding work orders or deficiency notices affecting the property, and that its present use may be lawfully continued, and the principal building may be insured against risk of fire. Seller consents to the municipality or other governmental agencies releasing to the buyer details of all outstanding work orders and deficiency notices affecting the property. So let's talk about what this means. This means that by the title search date, a lawyer has to have searched title. That's the thing you pay $32 for. Figured out what deficiencies exist on title, but they also have to have inquired of the municipality as to whether or not there were any outstanding work orders or deficiency notices by the title date. And they must do it by that date. Now, practically, a lot of the lawyer's work has been removed through title insurance, because title insurance provides an exemption for single detached single family properties. So if it's a non-duplex, or if it's just a unit or a property where one person is living or one family is living, title insurance says we'll protect you, and we will protect you. You do not need to do tax searches, nor do you need to do building searches at all. And if in fact, when this person takes possession of the property, they discover that there is a deficiency notice on title, which would have ordinarily been discovered had you done your searches, then we will protect your client. And so it's made our job a lot easier. We no longer write normally for building permits or work compliance questions. We actually don't even know they exist. And if they come up, you're title insured, and that's it. Having said that, if it's anything more than a single family home, the title insurance requirement is that we write to the city, pay them $115 in Toronto or whatever it is, and say, please inform us of whatever outstanding work permits are there. And then we have to write to the seller before the time set out here to say, hey, be advised there's an open building permit. Be advised there's a deficiency notice. Be advised there's a noise complaint. Please clear it before closing. And that's the seller's job. The reason you leave 2 weeks between, and it's best practice to put 2 weeks here, is because 2 weeks is deemed sufficient time to allow the seller to deal with the issues on title. So buyer is highlighting these issues to the seller 2 weeks in advance, and then the seller has 2 weeks to clean them up. Does that make sense? Anyone have any questions so far? I know it's 10:50, but I'm going to probably go straight to 11. Anyone have any questions so far? Okay. Section 10 cannot be read, Section 8 cannot be read without understanding Section 10. The two paragraphs really go together, because Section 10 is the heart of the agreement. And what it says directly relates to Section 8. So what's happened through Section 8? Section 8, the lawyer has technically gone ahead, inquired of all deficiencies, tax notices, building compliance, all the things on title, said to the seller, here are the problems, please clean them. And the seller basically responds pursuant to its obligations, and its obligations are set out in Section 10. And so what it says is, I'm going to transfer title to you. And title is going to be good and free from all registered restrictions, charges, liens, and encumbrances, except 4 things. Except any registers or restrictions or covenants that run with the land, provided they're being complied with. So if you're in a subdivision and it says no pink garage doors, you have to accept the property with that restriction, so long as the property doesn't have a pink garage door. If it has a pink garage door, you're entitled to demand that the pink garage door be reverted back to a color that's acceptable. Second point that the buyer has to accept, the seller does not need to rectify. So title can be good and clean, except registered restrictions, and B, any registered municipal agreements and registered agreements with publicly regulated utilities, provided such has been complied with and security has been posted to ensure compliance. So if there's a hydro agreement or if there's a water agreement, all of those things have to be assumed. C, any minor easement for the supply of domestic utility or telephone services. So if you think about it, everyone has internet at their home. You can't get out of an agreement because Rogers has a statutory easement to run a line over your property and attach to your property. You can't say, sorry, you're not giving me clean title because there's actually something that is attached to the property and goes over the property line. That is not a deficiency. It's an acceptable deficiency that you've agreed to accept pursuant to Section C. And then there's D. And D says any easements for drainage, storm, or sanitary sewers, public utility lines, telephone lines, cable television lines, or other services which do not materially affect the use of the property. So what's material effect? So the big case is a case that had someone's backyard, basically had a municipal sewer line that went underneath the entirety of the backyard, meaning that they were unable to actually build a pool, which was their stated objective. Does that materially affect the use of the property? The court found yes. If you had a big sewer line that was on the back 2 feet of the property, and you can't build on the back 2 feet because frankly of setbacks, would that materially affect the use of the property? Probably not. Everyone understand the difference? Okay. And then it goes on to say this, if within, I don't know why I can't highlight, but if within the specified times referred to in paragraph 8, this is how it ties into paragraph 8, any valid objection to title or any outstanding work order or deficiency notice, or the fact that said present use may not be lawfully continued, or that the principal building may not be insured against risk of fire, is made to the writing to the seller, which the seller is unable to remove, remedy, or satisfy or obtain insurance, save and except against the risk of fire in favor of the buyer. I'm going to explain this. And which the buyer will not waive, this agreement shall be null and void. So what does that mean? This is where 8 and 10 tie together. What it's saying is, I have until 2 weeks before to find a deficiency notice on title. I then have to write to the seller and say, I demand within the time period set out in paragraph 8 that you rectify the deficiency found on title. The seller must rectify that or provide title insurance, stating that title insurance will cover you for damages should it come to anything. That's what this whole thing about insurance is. And if they do not provide that, then the buyer can walk from the deal. Does that make sense? That's the heart of the agreement, what so many people ignore. So Section 10 is you, the buyer, have to accept title with the following 4 deficiencies. Even though it's clean title with these 4 caveats. We talked about that. What's more, we will answer your provisions of paragraph 8. But if we do not do so or provide title insurance coverage to you, then you are allowed to walk away from the deal. That is the heart of the deal. Does that make sense to everyone? Any questions?
Mark, have you been involved in a situation where 2 weeks prior, other than these acceptable deficiencies, something has been come up and a buyer has walked away?
Yeah. But I mean, generally, when the buyer walks away, it's because the buyer wants to walk and is trying to find a reason to do so. When I've acted for the sellers, usually those people are idiots. When I've acted for the buyers, we're totally within our rights. But yes, this is the job of the lawyer, right? Like, the whole idea is that the job of a lawyer is specifically to argue this and use the agreement of purchase and sale in the ways I've just described to get at what the clients are asking for at that time. Sometimes the buyers have change of mind. Sometimes the sellers have change of mind. Sometimes something is discovered and people want out of the agreement, whatever it is. But yes, that's been routine. We continually use these agreements. There's a reason. A mentor of mine once said that a contract is merely a collection of things that have gone wrong in the past. And that's the reason we have these provisions. And these provisions are there specifically because they are helpful and useful to all practitioners in the space on a continual basis. All right, with your permission, the closing arrangements. So this here is one of those standard forms that you probably can ignore unless you're a lawyer. But basically what it's saying is that from the lawyer's perspective, that the lawyers will agree to be bound by the DRA. So from lawyers who are on this channel, note that you don't have an option as to whether or not to be bound by the DRA. You cannot take on the file if you are not agreeable to be bound by the DRA. It says so right here, because those are your client's instructions. So I always laugh when someone says, I'm not going to be bound by the DRA. Well, screw you. And you can't operate on behalf of your client. Oops. And you can't operate on behalf of your client in the first place, because pursuant to section 11, that's there. Don't worry, agents. You don't understand what I'm talking about. Don't worry about that one. That's just for the legal eagles in the audience. Any lawyers have questions on that before I move on?
So you're basically saying, don't bother to argue with the other side if they're claiming they won't sign a DRA.
Right,
because
well,
section 11 covers us.
It's not that they need to be signed by it. They just need to agree to be bound by it. Just the same thing, right? So if they ever say to you, I do not agree to sign and I do not agree to be bound, just say, all right, how do you rectify that with section 11? Please remove yourself from this file or else agree. And if they say, I will not do it, then say, well, then I'm reporting you to the LSO.
Okay, so they don't have to sign it, but they must agree to be bound by it, is what you're saying.
That's correct. which is the
Okay,
same,
thank
which is
you.
the same thing in cause and effect.
Cause and effect. Thank you. So a lot of them just don't want to sign it. I don't know why, but
I
they'll
don't know
say
why
I'm bound
either.
by it.
Lawyers are, well, those lawyers, honestly, let's start making a list of them and then sending them bad Christmas gifts, right? Like that's what we're gonna do. This is where coal comes from in a Christmas gift.
Thank
All
you.
right. Let's talk about section 12, documents and discharge. So the buyer shall not call for any production of any title, deed, abstract, or survey unless it's in their possession of the company. Fine. Then it has the longest run-on sentence in history. And just because time is short, I'm not going to read it just to make it clear that people can make run-on sentences that last for hundreds of years. Instead, I'm just going to explain what it means. What it means is that if you have a mortgage from a major bank or credit union, you're not going to have problems on the day of closing. But if there's a private mortgage on title, this is, I'm skipping just because of time. If there's a private mortgage on title, then the payout needs to be arranged in advance. There is no obligation that the buyer's lawyer has to take an undertaking from the seller. So generally, if you think about it, when you go ahead and pay off a mortgage on the day of close, the seller's lawyer usually takes that money, pays it to the bank, and it's usually 15 or 20 days after that the bank registers the discharge and clears title, right? And the buyer technically is not getting clean title on the day of closing. But what this is saying is, don't worry about that. It's perfectly acceptable. The buyer will agree to accept the lawyer's undertaking, insured promise, to pay out the mortgage from the proceeds of the closing funds, provided that the payout statement that is provided to them is from a major financial institution, but not Uncle Bob. If Uncle Bob holds the mortgage, then you have to basically make arrangements to pay it out on the day of close. All of this is to say, from an agent's perspective, all you really need to understand about this is that if there is a private mortgage on title, please alert the seller's lawyer to that early, although they should figure that out pretty quickly. Sorry, guys, I would spend more time on it. It's just time is short and I want to just keep going through. Actually, it's 11 o'clock now. Maybe what I'll do is I'll continue. What I'm going to do is I'm going to continue part 2 of this. I'm going to schedule it for next week or shortly. And we'll do part 2, and then I'll go over the provisions of section 101 as well. So we're going to stop here, and I'm going to start with the inspection clause of Form 100, and then I'll do part 2 of this session afterwards, where I go through the remainder of this document. I go through section 101, and perhaps I'll even bring 111 into the mix and just go over that one as well, just so we're clear on everything. It's just, I don't want to rush through. And I think even if I had another 15 minutes, I'd still be talking. So maybe what I should do is just do this in 2 parts and divide out at this point. So let me turn to any questions someone may have in the last 2 minutes. Does anyone have any questions about what we talked about so far? And obviously we'll do part 2 of this, and we can discuss that further. Anyone have any questions?
As a lawyer, I noticed that quite a few times, paragraph 8, the title search date is either wrong in the past, especially when we do amendments, it never gets changed. Does this matter much?
It does, although if it doesn't get changed, remember that there is this provision here, which I can go over with you, but 5 days prior to completion is the bare minimus. So in the event that an adjournment has pushed it back by a month and has not addressed the title search date, you still have 5 days. You can still do it 5 days.
Sorry, 5 days before closing. So
5 days before closing then becomes the default title date. That's correct, pursuant to the terms.
Okay, thank you.
No problem. Any other questions?
Oh, Mark, you said that with no seal and no deposit was still a valid deal. And what was the reasoning for that again?
The reason is because the consideration is still present in the agreement. The consideration is the promise to pay the value of the purchase price for the promise to release the deed, to give you ownership. Okay.
Very good. Thank you.
Okay. Any other questions for me, or are we good? All right, so look for part 2. I'll put up the bat symbol at night. Just look to the skies. and we'll figure out when we're going to do part 2. But I'm away next week, so it may be that we have to wait 2 weeks to do part 2. But I'll make sure that we put this up as part 1, and then part 2 comes up shortly after, so people watching on video can see this as sort of seamless. All right, thank you all. Have a great day. Hope everyone is having a profitable summer, and I thank you all for attending.
Thanks, Mark.
Bye-bye.